So our next panel is on insider trading, and again, a terrific panel. Let me start with our first panelist here, Shannon Eagan, who is a partner in Cooley's Palo Alto office, where she serves as both partner in charge and head of the business litigation practice. She represents corporations and individuals in complex disputes and litigation, including securities class actions and SEC investigations and actions. Welcome, Shannon.
Thank you.
Very pleased to introduce Christopher Frey. He's a partner at Latham in San Francisco. He previously served for over 6 years as an AUSA in the Southern District of New York and also as associate counsel in the Office of the White House Counsel under President Barack Obama. Welcome.
Thank you.
Our moderator is Teresa Goody. She's a partner at BakerHostetler and co-leader of the firm's blockchain team. She has broad experience with securities litigation, investigations, corporate practice, and she previously served as litigation counsel for the SEC in its Office of the General Counsel. She's also very grateful to say she's our program chair of this event this year, and she'll be handling a lot of the introductions this afternoon. Welcome, and thank you. Benjamin Kingsley is chief of the Oakland branch of the U.S. Attorney's Office for the Northern District of California, and he has been an AUSA in that office since 2013. Thanks for joining us, Benjamin. And finally, Rahul Kolhatkar is assistant regional director in the SEC's Division of Enforcement in San Francisco, where he served for over 9 years. Thank you so much, Rahul, for joining us. Teresa?
Thanks, Bruce. Well, we have a very full panel, so I'll kick off right away with Rahul and asking about if you can talk about the SEC's priorities with us, some of the current priorities in terms of enforcement of insider trading cases.
Thank you, and I'll start by giving the standard disclaimer, which is that the views that I express today are made in my capacity as an assistant director for enforcement at the SEC, but do not necessarily reflect the views of the commission, the commissioners, other members of the staff, my colleagues here, anyone else. So to talk about the insider trading priorities, I think it continues to be sort of a core area of focus by the enforcement division. In the last fiscal year, the division filed 32 insider trading actions against 61 individuals, and the filings have continued to pace into fiscal 24. I wanted to highlight just a couple of examples to show where the priorities are and relevant to where we sit today. In March of this year, the commission filed a settled insider trading action against the former chairman of Arista Networks. We alleged in that action that the then chairman of Arista misappropriated MNPI about an impending acquisition of Acacia Communications, which was later acquired by Cisco. The complaint alleges that he obtained the information from a long-standing business relationship he had with another multinational company that was also considering the acquisition. And we also allege that he traded in accounts belonging to a relative and a friend. He consented to the entry of a final judgment at the time of our filing, and he agreed to an almost $1 million penalty and a 5-year officer and director bar in that case. So it's really relevant to the executives in Silicon Valley and the folks everyone in this room kind of work with day to day. We're going to talk about sweeps in a little bit, but in June of 2023, the commission filed 4 separate insider trading cases on a single day. The types of announcements are the types of announcements you would expect to create information asymmetries, mergers, tender offers, a SPAC's announcement that it agreed to acquire a target company, and a positive pharmaceutical announcement. But I also want to emphasize that insider trading and our concern about information asymmetries is not just limited to a classic 10b5 insider trading case. The commission is really concerned with how individuals, companies, registrants handle material non-public information. So in December of 2023, the commission filed settled charges against a private equity fund advisor, and that private equity fund advisor had portfolio companies, some of which were public, and they had policies around the treatment of material non-public information. However, principals from that fund advisor would email potential investors, current investors, and other individuals information that included MNPI essentially that related to M&A activity in the space. So the commission there filed a settled action, imposed a $4 million civil penalty, and the charges were actually under the Advisor Act, 204 Cap A, and the compliance rule. Another example of information asymmetries that the commission cares a lot about was highlighted in the recent January 2024 action against Morgan Stanley and a principal there. Essentially, the concern was this executive was disclosing confidential information about block trades that were coming up, and therefore allowing his clients to develop short positions in those block trades. So they would essentially have an advantageous position by participating in the block trades. They're all examples of individuals, companies, entities being entrusted with material and information and not taking due care with how they're handling that information. So I think that'll continue to be the commission's focus writ large, both with classic insider trading cases and sort of what I call insider trading adjacent type cases.
Thanks. And then moving on to the Northern District, some of the priorities in the DOJ collaboration, Ben. What can you share with us about the Northern District of California case priorities and securities fraud generally, and then insider trading specifically?
Yeah, thank you. So generally, we know that our district is home to a massive set of really valuable companies, both private and public companies. The 4 of the 6 largest companies by market cap are in our district. And a focus across our office is in protecting the market integrity, protecting the economy of the district. And we see that in a lot of different parts of our white collar practice, our cyber practice, our national security practice, our trade secret practice, and then obviously our securities fraud practice, where we're trying to protect sort of the value of those companies, the ability of people to freely invest in them, and the market integrity of people trading on those companies. And so insider trading cases, I think, fit within that framework. And I think it's helpful to think about them as just part of our fraud docket in the office, and another way to sort of emphasize deterrence on the most egregious forms of conduct. And we know the SEC is out there. We know the SEC does cases that are broader than ours. They will cover areas where the evidence is going to be potentially less egregious, or potentially more novel areas of the law or technical violations. So we'll also do cases where the SEC will sweep more people into a case because, for whatever reason, there may be 7 people involved in an insider trading ring, and 2 or 3 of them have done something very egregious, and 3 or 4 of them haven't. But we work closely with them and parallel with them to figure out what the right point is to bring a criminal sanction. And so I want to stop for a second, just because I get this question all the time, like what makes something into a criminal case in the insider trading context? And I think it's helpful to separate out kind of 2 questions. One of them is, can you prove the case beyond a reasonable doubt with criminal intent? And then the second is, even if you could, what does it meet your intake standards? Is it worth it from a perspective of, are you really punishing somebody for very egregious conduct? And on the first one, I think, the question when we're analyzing these, when it's coming in, it's incredibly clear that it's always, are we going to be able to show that the person was actually trading because of the inside information, as opposed to there's circumstantial evidence that maybe they had access to the information, maybe they profited from some trades. That is going to be the recurring question. It's going to come up when we talk about specific areas of enforcement that are kind of maybe more novel, or people are talking about now, whether it's shadow trading or something else. That is a core question. And there are going to be cases where the SEC is able to bring a case that we're not, because we're going to have to prove beyond a reasonable doubt that somebody was acting actually on the basis of the information and have a very clear, direct link, as opposed to sort of a set of circumstantial information. The second is this worth the impact? And there's several categories of things that we're looking at to decide whether to bring a criminal sanction on somebody for trading. The first and most obvious is loss or gain. When I went back and looked at the trading cases the district has done over the last 10 years, the sentences don't perfectly correspond to gain amount, but it's a highly determinative factor in terms of how our judges look at these cases, whether it's worth a criminal sanction. And we look at it the same way. And we see cases all the time where there might be a group of people involved, a bunch of downstream tippees who profit in the amount of $5,000, $10,000. And obviously, I'm not saying we wouldn't, obviously taking no official position on whether we prosecute that case, but I think everybody in the room knows that's a very different analysis than somebody who's profiting to the tune of $500,000. And a recent case that our office did, which involved an insider trading ring involving Twilio, which my colleague Garth Heyer prosecuted and is sitting in the front row like the nerd that he is. is a good example of that case. The lead tippee who was prosecuted by Garth profited to the tune of $500,000, was sentenced by Judge Tiger to a term of imprisonment. And at the sentencing, Judge Tiger said, these are very important cases to sentence to prison on because they're hard to detect and otherwise people are just going to do them across the board. That case also involved a bunch of other downstream tippies that the SEC brought cases against and that we haven't prosecuted. So I think that's a good example of kind of how we're seeing it. There's a lot of gain, obviously it's going to be more criminal. But there's other categories that I think are worth highlighting. Officers and directors are obviously going to be really important, sort of regardless. Gatekeepers, whether they're accountants, lawyers, people at BDs, investment advisors, that set of actors. We have to some extent less of that in our district than in New York, just because so much of the trading that happens here involves corporate insiders themselves, and maybe less the gatekeepers. But that's obviously going to be a focus too. So that's kind of how we analyze it and think about whether the case is worth going criminal or not.
And maybe just to piggyback on what Ben said, I mean, I think it's important to note the distinction in the remedies sometimes on the civil and criminal side. Ben raised a great point in terms of, the sanction on the criminal side is the sentence, right? And one thing that's important to us in our insider trading prosecutions is oftentimes not just the monetary amount imposed, but the collateral consequences, such as an officer and director bar, if the individual's an accountant or an attorney, denying them the ability to practice before the commission. So those sort of more injunctive type remedies are really important to the commission and how we view what to pursue.
And we look at that too. I mean, we know those exist and we know the SEC exists. And so, I mean, to all of the defense lawyers in the room, that one of the most effective things you can do to talk us out of prosecuting your client who maybe didn't engage in the most egregious behavior is to highlight all the ways the SEC is going to punish them and how that's a sufficient sanction for their conduct.
Yeah, I mean, in all of those discussions, the collateral consequences are oftentimes, the most pressing for those SEC settlements. And I guess just briefly, we're, well aware of the SEC and the U.S. Attorney's Office working together. I don't know if you can just briefly touch on the collaboration between the U.S. Attorney's Office and the DOJ's Fraud, Market Integrity, and Major Frauds Unit and kind of how that's impacting things.
Yeah, just briefly. I mean, we work really closely in parallel with the SEC. We get referrals from them. We collaborate on cases. We gather evidence together. Everybody has seen that. We also work with the fraud section. I think we'll talk more about data analytics. They have resources to do large-scale data analytics, and they have particular focuses on trading programs, healthcare fraud, trading in the healthcare context, for example. And we'll get referrals, and we work closely with them on that too.
Okay, thanks. And so what I've been asked about most recently is shadow trading. So we touched on it earlier in a previous panel, but the SEC has successfully argued that the trading in securities of one company based on material non-public information about a separate company can violate the federal securities laws. So Shannon, if you can kind of help us with a more thorough understanding of the Panawat case.
Yeah, so I know that Jason touched a little bit on this morning, so I don't want to retread too much, but the Panawat case obviously had a really recent jury verdict in the Northern District. And there, the SEC successfully pioneered what some may think is a new theory called shadow trading. And you're right, Teresa, it's about extending traditional theories of insider trading to situations where an individual has material non-public information about one company, here Medivation, and then goes and trades based on that information about the one company in the securities of another. And here, Panawat was the senior director of BD, business development at Medivation, and he became aware that Medivation was going to be acquired by Pfizer. It's funny, I was litigating a case for Medivation, not in the securities aspect, but I actually remember when we heard that Pfizer was going to be joining our litigation team. So kind of brought me back thinking about these dates. Just a few minutes after learning that information from Medivation CEO, Panawat went out and bought out of the money short-term call options in a company called Insight. Now, I think this case turns on a few issues. Of course, the SEC's charges rested upon the misappropriation theory, and the logic there was that Panawat owed a duty to Medivation as the source of the information to refrain from trading. And they argued that Insight was a closely comparable company to Medivation, and therefore these trades constituted illegal insider trading. Now, at the time, Medivation's lead product was a product called Xtandi, which was sold to help advanced metastatic prostate cancer. I think what's interesting is you'd think, oh, okay, maybe Insight had the same indication. No, Insight's lead product at the time was a medication to treat bone marrow disorders. And so what happened was the SEC argued that there was, in fact, a market connection between these companies, sort of despite the fact that they weren't in overlapping indications. And the crux of the matter was whether a reasonable investor would perceive that the information about Medivation would significantly alter the total mix of information available about Insight. So I think what this is really, these types of cases hinge on, and what we should expect is more work for the experts in the room. So congrats, everybody. I do think financial economists are going to be pulled in often on these cases. And it's really about whether there is a close correlation between, company A, the party to which the trading party owes a duty, and company B, the company which the trader is trading in. And another thing that I think is interesting about this case, and Rahul and I were just talking about this in the get ready room, the green room, was the language of Medivation's insider trading policy, and whether, had the language been different, a jury might have found something different. And here the policy stated, and I'll quote, "During the course of your employment with the company, you may receive important information that is not yet publicly disseminated about the company. Because of your access to this information, you may be in a position to profit financially by buying or selling or in some other way dealing in the company's securities or the securities of another publicly traded company." That language was fairly broad, and I don't know that that's in all of our clients' insider trading policies. And it was one of the three sort of pillars of a duty that the court found that Panawat had to not trade in this other security. And so I think there's a real question about, whether we should be advising clients to have that type of language, or whether we should think about, curtailing that language. And so that's kind of where I have in a nutshell. I don't know if there's more you want to add.
I guess if I could just jump in on the last point. I think one thing to flag is that issue of where this duty arises from was litigated at a motion for summary judgment. The court ruled that there were three sort of independently sufficient potential areas that gave rise to the duty: the policy, which Shannon mentioned, the company's general confidentiality agreement, as well as Panawat's general duty to keep his employer's confidential information that he was entrusted with confidential. And the language in the order on motion for the summary judgment held that any one of those three would be sufficient to meet the breach. So I guess on the question of counseling point, I defer to outside counsel on all those. But I don't know that trying to narrow the policy would necessarily get individuals around the duty in that situation.
Yeah, I don't know what a jury would think in that. I hear you on what the judge thought at motion for summary judgment, but I think that I can imagine jurors really sitting down and looking at that language that I just read and thinking this is what put this person on notice that he couldn't go trade in this other company, and that could be something that moves a jury.
Yeah. And with that, what kind of compliance impact do you see this having?
Yeah. Well, I think, look, we talked about it. I think companies clearly need to look at their policy and be aware of what they say. Is it a broad policy? Is it a narrow policy? Do you want it to be a broad policy? Do you want it to be a narrow policy? Those are things that GCs and executives need to think about. So know your policy, consider whether you need to revise it. And clearly you need to be educating your employees about the policy. I don't know whether there was any testimony about whether he was aware of that portion of the policy or whether that would have mattered. But I think it's, good compliance to be educating your employees about shadow trading, and in particular what your policy says about that. Continuing to use monitoring systems to the extent available, although query how hard that is to know whether your employees are trading in other companies that you may not, you're not FINRA, you don't get to all that information in the same way. So, but some type of monitoring to the extent you can would be helpful. Pulling in, legal counsel to help you on all of that. And then really considering whether 10b5-1 plans should be sort of expanded in a way that would cover, other industry players in that industry. But I think there's still a lot to be discussed and perfected in the what we do after this verdict.
I definitely think so, and I think we were talking earlier about areas where it might not be so easy to see the connection where this could come into play. And Rahul, if you want to talk about some other additional kind of compliance issues with private companies that maybe aren't, it's not as intuitive, I think.
Yeah, and I think I alluded to it earlier in referencing the OEP case against the private fund advisor is think expansively about how your company handles MNPI, what MNPI comes in the door, and how you want people to use that information internally. I think just not having a narrow view of I only have to be concerned about this if I'm a public company because that's the only situation in which I'd have MNPI. I think the Panawa case and the OEP case kind of show you have to think about MNPI not just in terms of your own company's traded security.
And shifting gears a little bit here to some additional existing kind of statutory tools that have been used to prosecute insider trading beyond 10B. We have 1348 and 1343 of Title 18, and both focus on the misappropriation of information, and Panawat did to an extent. That was one of the three independent bases. So I guess turning to this, we have the 1348 case with U.S. versus Barama, which is securities and commodities fraud. So I'll turn it over to you, Chris, if you can give us an understanding of the Barama case.
Yeah, absolutely. So Barama or Barama, I'm not exactly sure the correct pronunciation, was a Barama. Someone in the front knows. Yes, Barama. Indeed. Barama was a tippee. He was tipped by his friend Nalor, who was an IT administrator for Palo Alto Networks. And Nalor used his IT credentials to obtain highly confidential information about the quarterly earning and financial performance of the company, and then disseminated it to a total of 4 friends, one of whom was his friend Barama. They had actually met when Barama was a consultant at Palo Alto Networks. The company had a confidentiality policy in place, which employees and contractors were required to sign, and that policy barred insiders from disclosing any of the company's confidential information. The policy also prohibited employees from using confidential information to trade in company stock. And there was evidence that Nalor both knew about the policy and also had signed the policy. By contrast, while Barama had been a contractor in the department several years before, and that was the way in which, as I said, he had met Nalor, there was a lack of evidence that he had in fact received or signed the company's confidentiality policy. The 5 traders who were tipped, the 5 traders, including both Nalor and then the 4 who had been tipped, used the inside information to coordinate so-called straddle trades, in which call and put options were purchased just prior to Palo Alto Networks' quarterly earnings announcements, and then sold immediately after at a profit. And the scheme allegedly generated more than $7 million in profit. At trial, defense counsel contended that Barama did not know the information on which he was trading was stolen or confidential. Rather, he viewed Nallor as someone who was a trading guru and an advisor to him as to how to trade. Also, there was evidence at trial that Barama did not attempt to conceal his own trading activity. He traded openly in stocks and options using accounts in his own name. And then also significant, the government's own witness, an FBI forensic accountant, testified at trial that he found no proof that Barama provided payment to Nallor in exchange for the allegedly confidential information. And this was in contrast to other members of the alleged insider trading scheme who did provide Nallor with fairly significant benefits. The jury's verdict, in my view anyway, is rather interesting. The jury cleared the defendant, Barama, of the conspiracy count, the conspiracy to commit securities fraud count, and ultimately convicted him on 4 counts of securities fraud, which the government brought, as Teresa said, under 18 U.S.C. 1348. Relevant to, I think, the main issue on appeal, the government gave the jury the option of convicting Barama under one of the 2 prongs under 1348. The jury rejected the first prong of 1348, but found the defendant guilty under the second prong, which again goes to the appellate issues.
Yeah, what do you think we're going to be seeing with the Ninth Circuit appeal?
Well, I think the Ninth Circuit will be closely looking at the government's use of 1348 and whether it really fit the overall theme of the government's case. The government, in my view, presented a pretty standard case of insider trading and relied on a theory of misappropriation of confidential information by an insider, but chose to charge this not as 10b-5, but rather under 1348. And here the jury found, as I said, under the second prong of 1348, which requires that the accused obtain money or property by means of false pretenses, material false statements, or false promises. And on appeal, Barama contends that the government didn't prove that the money or property was obtained by that particular means.
Yeah, and Ben, obviously we want to look to you here. We won't ask you specifically about this case, but, is there anything new about the use of these statutes, do you think?
Yeah, so I think I want to say there's nothing new. Obviously, there's something new. There's been more of a trend of using 1348 in addition to or instead of 10b-5. And obviously, disclaimer, I'm not talking about the Barama case at all.
Right.
But across the country. And I kind of want to bring back the conversation a little bit on Panawat too, which is to say, from a prosecutor's perspective, we're going to look at these as misappropriation of confidential business information, generally speaking. And there's lots of statutes that can fit that. 1348 is a good one. 1343 is a good one. And it's not new for us to prosecute theft and misuse of confidential business information under those statutes. And we were talking before the panel about how Carpenter versus U.S., which is so the landmark case that says confidential business information is a thing of value under the wire fraud statute. That's a 1992 Supreme Court opinion in which the Southern District prosecuted a Wall Street Journal reporter for basically embezzling the Wall Street Journal's confidential business information to trade on it and profit. And there have been lots of cases since then that fit into that paradigm. And I don't think it's meaningfully different, from a conceptual perspective of people who are, selling corporate information. We've prosecuted those cases in our district, people selling consumer data or confidential information to outsiders, to malignant foreign actors. It just fits within that realm. I think, one of the things that I think is helpful when you look at it that way, you really focus on the fact that the victim is the company. And it goes to what you were talking about before in terms of compliance and how you want to write your compliance programs. We're going to be very receptive from a prosecutor's perspective. Is this something that violated company policy? Is this something that the company cares about? And generally speaking, I would like to think that most companies don't want their employees to be benefiting from the misuse of their confidential business information in a personal capacity in any number of ways. And if you change your policies to say that you don't have to protect confidential business information, then don't come crying to the government when somebody steals your trade secrets, because it's sort of going to be a pretty similar question. So I'm not sure that it's new from a fitting into the broader set of prosecutions, I do think some of the legal questions that are presented by the use of 1348 specifically are new, and I think that some of them are going to be touched on in the Barama appeal. I think some of them have been touched on in the Blazek cases out of New York, which involved CMS information and the question of whether government regulatory information counts as a thing of value, basically under the fraud statute. So I think a lot of that has to be litigated, but I don't think that the conceptual question of using these statutes is new.
I also think, if I could just interrupt for a minute, I mean, I do think that what this also shows is that, the DOJ obviously has more and different tools than the SEC does when it comes to insider trading, and that its choice about what statute to charge under really does, in my view anyway, turn on where the government views there are weaknesses in the case, right? I mean, I assume, and I know Ben won't comment on this, but I assume the decision to charge this as a 1348 case rather than a standard 10b-5 case was lack of benefit to the tipper and the tippie's awareness of benefits being given to the tipper for the confidential information that was being disclosed. And that is obviously sort of the hallmark, requirement via the Dirks case under 10b-5. So, where the government feels that it's perhaps lacking in certain evidence or where its case isn't particularly strong, it will choose what tool in its arsenal, I think, to use.
Yeah, and it's interesting that some of these Title 18 statutes seem to be a little bit broader, and you can kind of you don't have all the requirements of 10b, which takes us nicely to 1343 with the wire fraud and the NFT insider trading case. It was an insider trading case in quotes, but it was brought under wire fraud with OpenSea. And, another issue there is because, there was no requirement, right, to say that NFTs, to prove that NFTs are securities, and therefore insider trading, and brought it under wire fraud. So in that case, it was the misappropriation of confidential information of Chastain, a former product manager at OpenSea, and he was convicted of wire fraud and money laundering. And he relied on this confidential information and bought dozens of these NFTs he knew were going to be featured on OpenSea's homepage, and then so he used it for his own personal gain. So this has been seen as the first criminal insider trading case involving NFTs. So Chris, kind of sticking with you a little bit on, what are some of these key takeaways? What do you see kind of going forward in your crystal ball?
Well, again, I think this is another example of where the government either feels that it can't establish something or isn't ready to sort of take on the burden of having to establish something. It'll choose a tool in its arsenal that will work in order to presumably allow it to get to a conviction. Here, obviously, even though this is a case out of the office that I was once a part of, the Southern District of New York, which is a very humble and shy office, but there was a lot of fanfare about how this was the first ever digital asset insider trading scheme. How this was insider trading when it was announced, but nowhere in the indictment did the word security appear, and that was intentional. The government didn't want to take on the burden of having to establish that the NFTs qualified as a security. And so, I think we'll continue to see this because I think as criminal conduct evolves with the times, it's not necessarily the case that particular conduct as we traditionally think of it is going to fit those facts. And so the tools that necessarily have been used traditionally will have to, there'll be a give and take among what's being used.
Yeah, it seems to show that I think these traditional tools, right, are effective at new technologies, at getting bad actors, and whatever the technology is, there's a tool out there, right? Well, there definitely have been, a lot of cases that seem to be based on some data analytics. This has come up quite a few times now with, the SEC naming, charging 13 defendants in 4 separate insider trading schemes on the same day and things like that. So I want to focus a little bit on some of the data analytics by the different regulators. So Rahul, how do you think that data analytics will affect the SEC's generation and prosecution of these cases?
Sure. So, data analytics are sort of central to identifying potential instances of insider trading and really serve to streamline our investigations. The Market Abuse Unit has been pretty open about the fact that it has an analysis and detection center looking for aberrant trading patterns, and it's able to do so relatively quickly. I'll give a couple just quick examples. The commission in August of last year filed a case against Romero Cabral de Castanedo for trading in material non-public information concerning the client of a global law firm where he worked as a visiting attorney. The complaint essentially alleges that he accessed the information about the law firm's work for a biopharma client's acquisition, and then he traded it before a May 2023 announcement. If you think about that timing, the commission's action was brought maybe 3 months after the trading at issue, and that's simply just not possible without data analytics identifying the issue. You mentioned the 13 cases against the 13 individuals charged in 4 separate cases. One of those in June of 2023 was against a Pfizer employee who traded in advance of the announcement of positive clinical results for Paxlovid, which I think we're all familiar with. And he bought short-dated, out-of-the-money call options, which is sort of a telltale data sign that there was potentially riskier trading in a security. The individuals in those cases, in the Pfizer case, in a single day generated nearly 2,000% gains and nearly 800% gains on their trades. And I don't know if anyone in this room has ever had a day like that, but
I wish.
It seems unlikely.
If you did, don't tell anybody. Definitely don't tell them.
They already know.
And the insider was convicted after a criminal trial in the Southern District recently, and it's just sort of identifying those aberrant patterns really leads to promising leads for investigation, because insider trading cases are, as we've talked about in the cases we've talked about, very, very, very fact specific and resource intensive to pursue.
No, that's really helpful and insightful. And those are very quick turnarounds for those cases. And Ben, is there anything about data analytics that you see affecting the DOJ's generation and prosecution of cases going forward?
Yeah, and Rahul covered most of it. I think we've seen more referrals that are coming from data analytics. The fraud section's engaging in, I think, pretty widespread data analytics and has access to a lot of information, especially officers and directors that are reporting transactions, but sort of more broadly than that. It kind of goes to the point that I raised before, which is, from our perspective, we're trying to select the best cases that are going to have the highest impact and have a big deterrent impact. And so obviously, the vast majority of things that are going to be identified through data analytics are not going to be a criminal case. Many of them probably aren't going to be an SEC case, because there's lots of reasons data can show different things. But it's going to give us a broader field of cases to work from. It's also signals to the marketplace and the world, we're watching you. And I don't mean that in a creepy way, but maybe I do just a little bit, that we can't prosecute every single case, but there is going to be a broad set of information that's flowing into the SEC, that's flowing into Main Justice, and going out to the U.S. Attorney's offices. And we're looking for cases that are really egregious and are worth putting in our resources, as Rahul said, because they are so fact intensive to prove.
Is there anything about the data analytics that's impacting how you're defending these cases?
I would say data analytics have been around for a long time. They're obviously getting better and more powerful, but I think that, common sense is more about counseling again, education. I don't know that it really impacts how you necessarily defend a case once you're in trouble, but I certainly think it's a big part of avoiding getting into trouble, is making sure your clients understand that there are very powerful tools out there that the government is using, and they're clearly going to get better and better. And consider whether you should be looking yourself, making sure your shop is clean by using your own data analytics to try to suss out anything that's wrong. I don't know.
Yeah. No, I totally agree with that. I think that, it just shows that the government's efficiency and precision in bringing these cases is just increasing. And so it actually presents, I think, a teaching moment for compliance, legal personnel within the company to sort of use to instill within employees of the company and executives within the company that to sort of instill sort of fear and obedience, right? That the government is able to bring these cases a lot faster and more precise than ever before. And so it's just incredibly important to be extra vigilant.
Yeah. And it's interesting too that data analytics, looks like it was effective in the first criminally prosecuted insider trading based on the filing of a 10b5-1 plan, right? In the Pfizer case.
Yeah. This is an interesting case. I read the indictment the other day, and honestly, to me, it shows that not just my 13-year-old should be careful on her cell phone, that this is a case involving the chairman of the board of a healthcare company called OnTrack, and he entered into a 10b5-1 plan, and in order to avoid $12 million, that's a big number, right? In your world. Yeah, $12 million in losses when he had knowledge that the company's leading customer, Cigna, planned to terminate their contract early. And this is one of four main customers, so a very significant event for the company. Pfizer moved to dismiss the indictment in an effort to say that he possessed the information that he possessed at the time was public based on what OnTrack had said. What OnTrack had said is that key customers may decrease their enrollment rate levels, and the company had also lowered its guidance for the year. The court denied the motion to dismiss the indictment. I think there are a couple of interesting facts. I love insider trading cases because I think they kind of show people can be a little stupid sometimes. But and I apologize, but this person went to. Sorry if you know him, I don't. But this person contacted a broker to enter into a 10b5-1 plan. Broker A said, no, we won't do that without, our requirement is that you have a cooling off period. He said, okay, then I'm not going to do that with you. He went to broker B. Broker B advised him, look, we'll do this for you, but it's much better if you enter into a cooling off period. He said, I get it, we're entering into this, but I'm not doing a cooling off period. And then the indictment, the part about the cell phone that I started with, the indictment is replete with a bunch of text messages that this chairman of the board is sending into folks at the company with, silly jokes. The company's called OnTrack, and he's like, we need Cigna to stay on track. And, all these types of things, checking in continually on how the relationship with Cigna is going, not getting, positive information, and setting up these plans in the meantime. So clearly, the trial's next month, so all of what I said are mere allegations. But we'll see whether, this will be one of the cases we talk about next year, and what happens there.
And there were the motions rulings were kind of interesting in this case, Chris. Is there anything briefly you wanted to note about them? Chris.
Yeah, I think Shannon kind of touched on that a little bit, but the district court refused to throw out the indictment. It found that there was enough alleged by the prosecutors here. Pfizer had alleged that the indictment failed to allege that he possessed any insider information or that he used the information to trade company stock, and that the information he possessed actually was public because of what OnTrack had disclosed, and the district court, did not accept that. Found that there was enough alleged at least at that stage by the government. Whether it will carry its burden is a different question, of course.
Yeah, and on that, a little, we've been kind of teasing out the differences between, litigating with the SEC and litigating with the U.S. Attorney's Office. So I think the court said, look, this is an indictment, and I will not be incorporating anything by reference. I don't have that, luxury or whatever the court said under the criminal rules. And so in that basis, would not consider any of the public information out there about the company, and let the indictment keep going on that point.
And then just one other topic, which we'd be remiss if we didn't mention, but I'm sure the next group is going to mention it, is the data analytics in the crypto case, insider trading case, where in parallel, the SEC and DOJ brought cases against the ex-Coinbase product manager and his brother and a friend, and we'll leave it for that next panel to discuss it. Thanks so much.